obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. Magoo, and I expect those to be in the interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten the
He
video.
has all video discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure yet.
So, Mr. Magoo, are you going to have an objection to an adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So, given that that's not the case and the officers are not here, I would like a speedy trial. I would like to invoke my right to a speedy trial.
So you want your preliminary examination. Those are coming down to the jail to him.
Yeah, I expect that he would have them early next week, so if the court follows its normal setting for preliminary examination, I would expect.
I would set it for the 19th and then
have them as well.
he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination, it's being a critical process, a couple of things that the court wants to do. Mr. Magoo, starting in case ending in 0979. Mr. Magoo, you are before the court on a felony complaint that alleges 5 different counts, excuse me, fleeing and eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200 nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to immobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a 3rd offense notice, which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service. Any rehabilitative programs the court deems necessary. Court could order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody, or escape from lawful custody, excuse me. That's a misdemeanor, punishable by up to 1 year, $1,000 fine plus court costs. Mr. Magoo, yeah, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I will. I have requested assistance, given that I am incarcerated and I have no way to.
You wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be
Well,
represented by?
I've called the
Well, Mr.
prosecutor.
Magoo, we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. that I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I've advised you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will.
All right, this is not your average courtroom video. This one is a full-on legal chaos compilation featuring a sovereign citizen defendant who has been tracked across multiple hearings, multiple charges, and multiple chances to get things right, but keeps doubling down every single time. And what makes this case especially interesting is the contrast between two worlds colliding in real time. On one side, a structured legal system that runs on procedure, evidence, and precedent, and on the other, a defendant who believes that personal interpretation of law overrides everything else in the courtroom. Now here's where things get even more intense. This isn't just one hearing. This is a build-up, a pattern. We're watching decisions stack on top of each other. Refusal of counsel, repeated legal arguments that don't align with court procedure, and a growing frustration from the bench as the case progresses that you're going to see moments where the judge tries to keep things grounded, moments where the defendant pushes back with constitutional arguments, and moments where everything nearly derails because of misunderstanding of basic.
He also failed to appear before the judge's place. So
Yes.
that warrant would also hold up with respect to the other comments. I'll wait. If there are pleadings filed by the defender's office, our office will respond to that. And I guess my one remaining point would be, with the court's appointment Eastern the Public Defender's Office, I will make sure that the digital discovery that I referenced is served on the defender's office.
Yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination, and I realize where this may be. My understanding is that he is still being held, regardless of what the bond would, in this case, he's being held without bond in Judge Slay's case.
That's my understanding.
That his bond has been denied. So
That's what I
would
Mr. Curtis said.
in any event, but also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in his bond in this case, that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And
I understand the presumption of innocence.
and a lot of these are fake.
From setup, but already the tone is tense. The defendant begins raising statutory arguments, specifically challenging the interpretation of legal definitions tied to confinement and custody. Now, in theory, questioning the elements of a charge is not wrong. That's actually part of a defense strategy. But here's the key difference. Timing and procedure matter. These arguments are typically raised during structured motions or evidentiary hearings, not as broad objections during initial proceedings. What stands out here is the confidence in legal interpretation without procedural grounding. The defendant is essentially trying to collapse the case by attacking definitions directly.
Preliminary examination in this matter will be set August 19th, 2025, 12 noon. That is before me on that date for both of these cases. I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh, yeah, in that regard, Your Honor,
Many of those, do not interrupt me. Including many that I don't even know the connection. Court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with court. I consider it, quite frankly, to be frivolous. The complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen, and that is attempting to manipulate the system. He will be dealt with by me as I would deal with any other defendant, and so that is there. It has been turned over to the Office of General Counsel for the Washtenaw County. They will deal with, for me, and as well as the others that I see that are listed there, they will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people of individuals without specific reference in the Washtenaw County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in handling this case. So,
I'm aware of such filings were being received by our office maybe yesterday. At this point, we continue to proceed with this case until I hear otherwise from the elected prosecutor.
can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction. Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here.
Dynamic is starting to shift. The defendant escalates into constitutional arguments, Fourth Amendment claims, challenges to licensing requirements, and demands for procedural dismissal. But here's where reality kicks in. Courts don't operate on assertion alone. They operate on burden of proof, structured motions, and evidentiary standards. That's especially important here is the judge's tone. He's not dismissing the arguments emotionally. He's dismissing them procedurally. That's a key distinction many people miss when watching these cases. The judge is essentially saying, even if you believe you're right, this is not the correct stage or method to raise it. And that's the silent tension in this entire exchange. One side believes they are dismantling the case legally, while the other side is simply keeping the process aligned with
back on June 14th of 2025. I do have to tell you, both ladies, and apologize in advance. I have gotten us behind just through my fault and my failure to move these cases as fast as I'm supposed to move them this afternoon. So I'm a little bit short on time. I don't have time to take extensive testimony on it. I think what I'd like to do is let me see here. Okay, so we're just going to have to keep it quite short. And I guess the way I'll do it is I'll swear in Ms. Gay, take her testimony as to the basis for the PPO. I will hear in a response from Ms. Campbell why I should terminate the PPO, and then I can make a ruling. So, Ms. Gay, if you would please raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do.
Very good. And to support this protective order, you stated that there were a couple of incidents here, one of them being Miss Campbell throwing eggs at your house. Tell me what happened on that occasion.
After the incident happened, after the altercation with, her and everybody else on the Hall Street,
Yes.
they threw eggs at my home.
Was
And
it
then
during that same big brouhaha on the blow up, or was it later that day or in the evening? When did it happen?
later.
Okay. All
And
right.
then
And who are the egg throwers that you saw?
Renee and her daughter.
And you saw them actually throw eggs at your house?
Yes, because the next day she was on the neighbor's porch, just keep yelling. I didn't throw eggs. I have cameras all around my home, all around it. And I have my cameras, if you come anywhere towards my perimeter of my property, it captures you. It was her and her daughter.
Critical because it highlights a major misunderstanding and self-represented defense strategy. The belief that charges can simply be dismissed through oral argument alone. The judge shuts that down immediately, and for good reason. Dismissal at this stage is extremely rare unless there is a clear legal deficiency on the face of the complaint. Instead, what the court is doing is pushing everything toward the proper procedural step, a preliminary examination. That's where evidence is tested, witnesses are evaluated, and legal sufficiency is actually assessed at SO when the judge says that motion is denied. It's not personal, it's structural. The system.
Okay. And my next question, you said you submitted the films, you submitted them to the police department when they
Yes,
were
I did.
reported?
The lives that people were sending me, as soon as they sent them to me, with her ranting and raving about how she was going to kill me, I went right downtown to the police department and I sent it to them. That's two of her telling me she's going to threaten me. I got one actually with her video, and I have her ranting in the backyard, just yelling and screaming and scaring my grandkids, telling them that how she's gonna hurt me. And it just went on and on. And I have witnesses, guests over, like, oh my God, you have to listen to that. I'm like, yes. She keeps
Okay.
threatening
Well,
me.
let me see what Ms. Campbell has to say about it. Ms. Campbell, would you please raise your right hand? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, I do.
Very good. Ms. Campbell, you
Well,
say in your response here, you think there should be a termination. It does say you're off probation. What were you on probation for?
I was on probation for the incident with her daughter and stuff, and ever since I've been off probation, she's been harassing me and my I have an 18-year-old daughter, and so she has a daughter that's my age or whatever, and stuff. So basically, ever since that incident, she's now that her daughter, so she basically got her daughter, her grandkids, and like her nieces and them making up stuff. I never once threw eggs at her house. I never said
I
nothing
got
to
pictures.
her. She came to my house, her
I
and her
do.
daughter and her
I
grandkids.
do.
I
Hang on,
never
you gotta let her testify, Ms. Gay, and then I'll give you a chance to respond.
I never now since she came to my house, that was May 31st. I have two incidents from this year. May 31st, which I put in the
Discussion. And this is where things become significantly more serious, and a court sets bail conditions. It's not just about punishment. It's about risk management. The judge is evaluating flight risk, public safety risk, and compliance history. And in this case, we see multiple layers of concern. Prior DUI allegations, failure to appear, and alleged refusal to comply with legal process. That combination creates a legal profile that courts typically treat very cautiously SO when high bail conditions and monitoring requirements are imposed. It's not random. It's a response to behavior patterns already documented in the record.ND. This is where perception matters. What the defendant sees as unfair restriction.
said nothing before then, and I never said nothing after. She's just trying to prolong it because now that she's wants to get in the mess with her daughter and her grandkids. Now she's trying to say this and that or whatever and stuff. And that was she made the PPO what June, May, my daughter's birthday was May 25th. So it was sometime after like then in July in June or something, that's when she's making these reports. I never threw eggs at her house or whatever, and I would never turn my 18-year-old daughter to throw eggs at her house. She called she said she never called the police. If I threw eggs at her house, why didn't she call the police? She came over here with a mob of people, her whole generation and stuff. It's only me and my daughter and my 9-year-old daughter. You look, I have a 9-year-old daughter and an 18-year-old. Today, my daughter turned 19, so they're 10 years apart. That's not true. I never said I left in an ambulance. They assaulted me, her and her kids. And she has the background. You can look on the camera. She drove her car over to my house. I never once went over to her house. She
Well,
came over
you're
to
talking about the big fight that happened in the street on Zeno Street?
it didn't happen. It happened on Hall Street, not
Or Hall
Zeno.
Street? Okay.
Yes, she came over. Her family came over to
Yeah,
my
I
house.
don't want to reissue the fight because she's saying, well, since that fight, this
Nothing never
thing
happened.
escalated.
Since after that, yes, she's been calling CPS. They've been calling the city. They've been calling, making now she's trying to do a PP and fearing her life or whatever. Lady, I've been staying here for 3 years. I never, come on now. I never said nothing to her. I never, some eggs. It,
And you're not yelling at her from the back porch where she could
no,
hear from her
no,
house.
I am not. You can ask the judge. You can get active and come to the neighborhood. I've been staying here. They saying that me and my kids now she's going around saying my 9-year-old daughter with a taser. They brought the taser to the fight, and then my 9-year-old daughter
Yeah,
picked it
well, the
up.
taser's not part of this
I
PPO, so
know,
I'm gonna
but this
leave
is
that
it.
thing
But it
alone.
was led up to is what leading up
Yeah,
to this
I get
mess
it.
or whatever and stuff. Um,
Let
I
me
never
bounce
said
back to
nothing.
Miss Gay and ask her about that. Miss Gay, have you been making CPS calls about Miss Campbell's parenting?
I have never called CPS. Miss Campbell, Judge, I have proof of everything that I've submitted. I have proof of her. I have my ring camera is what her coming in the backyard yet threatening me. I also have her on Facebook. I have all of the recordings. As far as her talking about, I came around and Miss Campbell don't understand it. She doesn't want to tell the truth. When I came around there, I tried to ask them not to have any altercation, and she keeps making up this stuff like nobody wants to harm her. I don't have no business like messing with her, and she doesn't have any messing with me. I'm not that type of person. She was found guilty for whatever reason with her and my daughter. I don't get in that stuff. I'm a whole grown person and an individual. I ask that you please keep this granted, because ever since you've granted this PPO, the yelling has stopped. I have not been threatened.
Jurisdiction argument. This is one of the most common sovereign citizen talking points, and also one of the least successful in actual court proceedings. The defendant questions whether the court has authority, attempts to distinguish between different legal classifications of jurisdiction, and suggests procedural invalidity. But the judge's response is firm and direct. Jurisdiction is not in question. The court has already established authority over both the person and the case based on geographic and statutory grounds. That what's important here is how quickly the judge shuts down the philosophical framing. Courts don't engage in abstract legal theory debates during active proceedings. They rely on codified jurisdiction.
Things like that. I really don't feel like I can make a decision on the termination. So what I'm going to have to do is I'm going to adjourn this hearing to a future date. And my question to you then, Miss Gay, is to show me those videos. Would you be
Yes.
able to do it in a Zoom format like this, or are you going to need to come in
Yes,
the courtroom?
I can, I don't know how you do it on Zoom. I can even send it to you via email. I have
You can
all of
send me
it.
the files via email?
Yes, I can. If you give me an email address, I'll send it to you right away, sir.
Okay, let's do it that way, and then I'll have a look
Yes,
at them, and I can also email them then to Miss Campbell so she can look at them, and then
yes.
we'll have them ahead of the next hearing. Miss Campbell, did you have a question or something to say? You're muted, ma'am.
I have evidence, too, sir, and I would like to, present, the evidence, which she should have been presented the evidence. She been did this in, June, so why didn't she present the evidence?
Well,
Basically,
she
her
sent it
daughter
with the
is
police
coaching her.
report, but
Basically,
I
her
can't get
daughter.
it. I can't look at it. If she submitted to the police download, they do have an evidence.com site, but it's not something that I can easily access. Um, uh, you know, it's just easier for her to submit it directly. Because really it's a separate case. This is a civil case. It's got nothing to do with criminal activity, although I know the underlying things that do involve some police reports. Ms. Campbell, what sort of evidence do you have that you would like to submit?
I have the police report from that day, that she said, with the eggs, throwing. I have that evidence, and I also have the evidence when she came to my house with her and her daughters, and I also have evidence. She's saying the stuff about with her daughter. That have nothing to do. That's why she's
Yeah, it's a separate case. I get it.
so,
I'm not
and she
considering
keep
that.
it's nothing. I don't have now she brought this among herself, and then two, you're a judge. You can go to CPS. You can go to
Well, you
CPS and
might think
see.
that a lot of people think it's that easy, but the truth is I don't really have much better access to CPS and records of that sort than any other person does. I'd have to obtain releases and all that stuff. And the truth is, in the context of a
Well, I
personal
have the
protective
proof.
order, we don't typically do it that way.
Well, I have the allegations and the reports and stuff, and the stuff that her daughter is saying too, because basically her daughter is coaching her. Um,
Okay. Well, I mean, if it's attributed to her and you think I should read it during the hearing or advance of the hearing, you
okay,
can submit it to me. I'll take a look at it and then I'll
okay.
try to make the best decision I can at the next hearing. And any documents or evidence that you want to submit, we can take scanned copies or photos by email, and we can also you can drop off.
This is your first appearance since the service of that warrant. Ms. Arnold, how would you like to proceed with Mr. Thorne's pretrial conference at this time?
Yes, Your Honor, I just want to confirm with the defendant quickly that he was able to go over the SOC with Mr. Reardon over the phone.
Yes.
Okay. And you have no questions about that?
I mean,
If you have any questions, we can go in a breakout room and you can ask me. I just want to make sure that everything was gone over with you prior to going on the record.
I don't agree. I don't agree with any of this, but I don't really feel like it matters. I'm just trying to get it done in the least way possible.
Mr. Thorne, so I have to state that anything that you say can and will be used against you at trial later on if that's what you decided to do. So if you have any questions or concerns or anything that we could go into a breakout room, okay? So I think going in a breakout room would be appropriate, Your Honor.
Questions. I just want to get out of jail. So it don't really matter.
Thorne, if we could please go in a breakout room.
Of course. Mr. Thorne, you're going to be receiving on the screen there in front of you an invitation to go into a breakout room so that you can speak privately with Ms. Arnold. Please accept that. After the two of you have completed your conversation, we can proceed with this case.
Set it up this way. So I'm gonna plan to stay in jail for a while then.
Mr. Thorne, everything that you state can be used against you at trial. So please refrain from stating anything on the.
It goes to will, man, and I know that. But you know that too. Ever since the day one.
Thorne, please.
No. You guys are just gonna keep me in jail? For what?
Mr. Thorne, please.
Madam Clerk, the city is this still being recorded? The city's requesting. Oh, Is it possible for the city to obtain a copy of what was just said? Okay, thank you. And given the defendant's statements, the city is asking that we go back on the record. Even the city won't make any statements, but I would like to have a clear and accurate recording. If anything else is said before the judge comes back, we could go back on the record so this can be recorded.
This is one of the most important parts of the entire hearing. The judge is essentially giving a formal warning about self-representation, and not just once, but repeatedly emphasizing the risks involved. And this is not dramatic language. This is experience-based caution. Courts see this pattern often. Defendants underestimate the complexity of legal procedure and assume they can navigate it through logic alone. But criminal law is not intuitive. It is technical, procedural, and highly structured. The judge's repeated advisement that he will be held to the same standard as an attorney is extremely significant. That means no leniency